Hello all, hope you're well. Today's date is the 27th of June 2025. Nothing in this video is to be construed as legal advice, for it certainly is not. If you'd like to contact me, then feel free to email me at fraudunravelsall@mail.com, and please like the video if you think it has value, and feel free to subscribe if you fancy seeing more videos from this channel. So, it has come to my attention that Haste Ltd makes sneaky and potentially criminal moves to try and get out of responding to Dsars by stating they are not data controllers and neither have they processed or come into contact with any personal identifiable information, and then they try to redirect you to the so-called energy supplier. They may even try to tell you that, following guidance from the Information Commissioner's Office, Haste will now consider this matter closed. Whoa there, criminal fraudsters, not so fast. Right there, Haste fail in its statutory obligations, which means it leaves itself wide open for a complaint to the Information Commissioner's Office, but probably far more importantly, or legal proceedings for obstruction under Data Protection Act 2018, Section 173, and or compensation under Section 168. Make no mistake, Haste Ltd is legally obligated to provide any identifiable data, whether it has your name on or not. Haste Ltd deceptively use a pseudo department called Revenue Protection Services for all its unlawful and dodgy dealings regarding those debt collections for energy suppliers, and any paperwork received from Haste will only ever give a PO box address and an email address, which is RP, as in Roger Papa, services at hasteltd.co.uk. Therefore, if it was me, I would also email the Dsar to Haste's main email address, which is support@hasteltd.co.uk. But you're going to see both those email addresses on the screen shortly, and they will be available to you. There are specific criminal offences related to Dsars, such as it is a criminal offence to alter, deface, block, erase, destroy, or conceal information with the intention of preventing disclosure of all or part of the information. Repeat, guys and girls, it's a criminal offence. And legal proceedings for obstruction can be commenced under Data Protection Act 2018, Section 173, and compensation can be sought under Section 168. Why? Because it's criminal. So, Lawkeeper drafted a Dsar especially for Haste and other dodgy companies, which is designed to cut them off at the pass regarding their shenanigans, and to let them know that you know. I will put this Dsar template into a free Dropbox file share and leave the link in the description. I suggest that the moment you get any paperwork or an initial visit from Haste, then on the same day email them this Dsar to both email addresses. Now, let's look at the Dsar. So I'll just quickly read through it. Data subject access request, Haste Ltd. Put your name, email, Data Protection Officer, legal compliance, insert their registered address if known, easily found on company's house. Their head office address found on the website is different to the registered office address. I always use registered office address and email as well. Okay, subject, data subject access request under the Data Protection Act 2018 and UK GDPR. Dear Haste Ltd, this is a formal data subject access request Dsar made under Article 15 of the UK General Data Protection Regulation, UK GDPR, and Sections 45 to 47 of the Data Protection Act 2018, DPA 2018. 1. Statutory obligations, controller or processor. You are legally obligated to respond to this request regardless of whether you claim to act as a data controller or as a processor on behalf of another entity. The definition of personal data includes any information relating to an identifiable individual, DPA 2018 Section 3.2, UK GDPR Article 4.1. This includes data tied to a postal address or email account. Processing includes collection, storage, receipt, reading, dissemination, deletion, and other operations, UK GDPR Article 4.2. Even where you are instructed by a third party, such as an energy supplier, your obligations under UK GDPR Article 28.3 and DPA 2018 Section 59.1 remain binding. If you have visited any premises, handled correspondence, sent letters, stored address-linked files, or retained digital logs, then you are processing personal data and may be acting as a controller, a joint controller, or a processor, each of which invokes duties under the UK GDPR. You must not refuse this request on the basis that you are not the data controller without lawful explanation, and you must identify the true controllers if you claim to act on their behalf. DPA 2018, Section 44, 1A. 2. Information required. Under UK GDPR Article 15 and DPA 2018 Section 45 1-2, I request A. Confirmation as to whether personal data relating to me has been processed. B. Access to the following: the purposes of the processing, the legal basis relied upon, categories of data processed, categories of recipients, including third countries, or international organizations. Source of the data if not collected directly from me. Retention period or criteria used to determine that period. A copy of all personal data held or processed, including but not limited to postal correspondence received from me, email communications received from or sent to my email addresses, internal records, logs, notes, or metadata about any such communications, third-party instructions under which you acted, if applicable, copies of letters, notices, or home visit records connected to my address, and details of any data sharing or profiling. 3. Address level identifiability. Even if you do not hold a file in my name, any data tied to my home address, postal reference, or email domain is addressably personal data, per UK case law and ICO guidance. This includes documents issued or received to, from, the property at, insert your address, communications referencing any Royal Mail tracked or signed for items, technical logs, photographs, or contractor notes created during any home visit. You are required to search by address and communication history, not only by name. Format and deadline. Please provide the requested information in electronic format unless otherwise agreed. You are required to respond within 1 month under DPA 2018 Section 54(2). If you believe this request is complex and seek to extend the time limit under Section 54(4), you must notify me in writing within the original 30-day window, citing clear reasons. Failure to comply may result in a complaint to the Information Commissioner's Office or legal proceedings for obstruction under DPA 2018 Section 173 and or compensation under Section 168. Guys and girls, I kid you not. Come on. Come on. Strategize. See you all soon.